Okay, so state executive consists of the governor of the state, the chief minister, the council of ministers, and the advocate general of the state. Article Part VI, Part VI, Article 152 to 167 specially deals with the provisions related to state executive. State executive is also an independent constitutional authority in parliamentary dispensation that prevails in India. State executive has autonomous power and functioning with regards to state laws. It has much sovereign power, although in certain circumstances it has to act according to the direction of the central executive. So state executive is modeled after the central government at the state level. We have adopted a federal system, in fact a quasi-federal system, and where the state executive is normally independent and autonomous in many areas of functioning, except in certain areas where it needs the approval of the direction of the center. State executive is responsible to collectively responsible to the the state legislative assembly. In fact, we are talking about the council of ministers headed by the chief minister, who is the real executive. They are collectively responsible to the state legislative assembly, like the central executive or the council of ministers headed by the prime minister is collectively responsible to the lower house of parliament, that is Lok Sabha. So here the same pattern is followed. What I mean to say, in this section we are bringing some relevant questions, including the previous year ones on governor. And the office of the governor is one of the most debatable offices in the constitutional scheme. It has a lot of issues associated with it, but despite that, it is the highest constitutional office at the state level. The governor is the constitutional head, the nominal head or de jure executive head of the executive of the state. He is like the president at the center. He is also a constitutional titular head, and it makes sense. Office of the governor is borrowed from the East India Company dates. It was prevalent. The term was first used in the East India Companies as the head of the provinces or presidencies. Since that day, the office of the governor is associated with India. Today, in the constitutional scheme, governor is the head of the state. Article 153 says that there shall be a governor for each state. The governor's office will not fall vacant. He must be there at the state level as the president is there. But there are a lot of differences in the constitutional arrangement for president and those for the governor. Okay, governor is a nominal head and he is appointed, rather the president is elected, and president is a symbol of federation. Governor is the head of the state only, and apart from the head of the state, he is also a representative of the center. He watches the state government function in accordance with the constitution, and he reports to the president on the functioning of the state. But he is elected, and for president enjoys security of tenure. He is removed by the parliament only after impeachment resolution passed by the 2/3 members present and voting 2/3 members of the total strength of the house in each house. But in case of governor, he holds office during the pleasure of the president, and he can be removed at any time by the president on the advice of the prime minister without assigning any reason thereof. So the governor enjoys a very delicate position in the constitutional scheme. There have been many commissions appointed in this regard, because governor is at a very serious or a sensitive issue as so far as the center-state relation is concerned. He is at the pivot of the dispute or conflict between the center and state. Many conflicts surround the office of the governor, and it creates a lot of troubles, lot of issues with between the center and states. But so far there have been no changes in the existing in the constitutional scheme, although there have been many recommendations made by various commissions, including the RS Sarkaria Commission and MM Punchi Commission, which are relating to center-state relations in India. Okay, we will examine in this section some relevant questions related to the governor's office. Let us see the question first. Which of the following suggested that the governor should be an eminent person from outside the state and should be detached figure without intense political link and should not have taken in politics in the recent past? Who among the following? Means there are a number of commissions. There are six. So what does he suggest? He suggests that governor should be an eminent person from outside and should be detached figure from, means apolitical, should not have interest in active politics, and should be an eminent person, and it should also be from outside the state. There is also mentioned. These were the recommendations made by Sarkaria Commission. RS Sarkaria Commission was appointed in 1983, and it continued its report in 1988. And Rajmanar Committee was appointed by Tamil Nadu government in 1969 on center-state relation. First Administrative Reform Commission is there, also chaired by Moraji Desai. It is popularly known as Moraji Desai Commission. And National Commission to review the working of the commission constitution was headed by M.N. Venkatacharya. So RS Sarkaria Commission had made the recommendation that governor should be a detached figure in politics, and he should be an eminent person in different fields, different walk of life, any walk of the life. Eminent person must be, and must be detached figure, should not have interest in active politics. So answer will be C. Answer will be C. Question number 1, answer C. Consider the following statements. No criminal proceedings shall be instituted against the governor of the state in any court during the term he enjoys immunities from against arrest and detention and against issuing criminal proceedings. It is mentioned in Article 361. So this statement is correct. Remember, during its term only, not all times. The emoluments and allowances of the governor of a state shall not be diminished during the term of the office. It is mentioned in Article 158 Clause 4. 158 Clause 4. Article 158 Clause 4 mentions that the emoluments and allowances of the governor of a state shall not be diminished during the term of office. That means they are charged upon the consolidated fund of the state or state concerned. So that statement is correct. Okay, that statement is correct. Number 2. Question number 2, both 1 and 2 is correct. Yes, both 1 and 2 is correct. Are correct, that is C. Question number 3. Which of the following discretionary powers given to the governor of a state sending report to the President of India for imposing the President's rule? Yes, that is a kind of discretion that he may use under Article 356. Appointing the ministers is not a discretionary power. Appointing a minister, because governor appoints those persons as ministers who only on the recommendation of the chief ministers. Governor has no discretion. So it is not a discretionary power reserving certain bills passed by the state legislature for consideration of the President of India. Article 200 confers this power upon the governor, making the rules to conduct business of the state government. So that is there. That is there. So that is there. Okay. So that is also, but that does not is a discretionary power. It is a discretionary power. It is a discretionary power. So 1 and 3 is possible answer. No, 2 and 4 are not the discretionary power. So I think 1 and 3 answer is B. Answer is B. That is the things. Question number 4. Which among the following statement is not correct regarding the governor? Regarding the governor. Governor holds office for a period of 5 years from the date on which he enters office. Yes, that is 156. One person cannot be appointed as the governor of 2 or more states. Yes. Cannot be appointed. No. That can be appointed. Article 155 deals with this. By 7th Amendment, Constitutional Amendment Act 1956, it is provided that a person can be appointed as the governor of 2 or more states by the president, and when a person is appointed as governor of 2 or more states, his salary remains the same but determined, shared between the states as determined by the president. So that is not correct. 1 is A is correct. Not correct is B. Let us see. Let's see C. The governor cannot return a money bill. Yes, he cannot return a money bill for reconsideration. He cannot use suspensive bet on money bills. More than one above is correct. None of the above is correct. Incorrect. So only one is C is incorrect. B is incorrect. Look at question number 5. Which of the following statements refers to pardoning power? Consider the following statements. With reference to pardoning power of governor, he can pardon, reprieve, respite, remit, suspend, commute the punishment or sentence of any person convicted of any offence against state law. Yes. He can. You cannot say it is wrong. If a state law prescribes for a death sentence, he can pardon a death sentence. No, governor cannot pardon a death sentence. That is up to the president. It is given to the president. He can grant pardon, reprieve, respite, remission, suspension, commutation. So statement 2 is state for death, he can death, that is incorrect. first is correct. Third, he can grant pardon, reprieve, commendations in respect to punishment, punishment or sentence by a court martial. No. So are not correct. Which of the following statements given above? Which of the statements given above are not correct? Not correct only 2 and 3. Only 1 is correct. 2 and 3 are incorrect. Question number 6. Which of the following statement is not correct? Not correct. Number A. Not correct. The governor can issue ordinances when the legislative assembly is not in session or only when two houses are not in session. Yes. The governor can at his discretion issue ordinances whether the assembly is in session or not. No. The governor must be satisfied that exists with the render necessary for him to take immediate action. That is right. Article 2 and 3 deals with the ordinance making. The governor's ordinance are of the same force and effect as an act of legislation. Yes. So only B is incorrect because not at his discretion but can issue the ordinances only on the Council of Ministers headed by Chief Minister. Article 2 and 3. Okay. Okay. So answer is B. Not correct. Question number 7. When a bill passed by the state legislature attempts to take away the powers of the High Court and is presented before the governor for his assent, he may give his assent. No, he may withhold his assent. That is not possible. Is bound to return the bill for consideration? Not, but is bound to reserve the bill for the consideration of the President under Article 200. There are certain circumstances where the governor can reserve a bill passed by the state legislature for the consideration of the president, that is almost related to federal nature of the government, federal nature of the polity, or federal aspects where the governor will not give his assent, rather he will submit it before the consideration of the president under Article 200. So powers to taking away the High Court, attempt to take away the powers of the High Court is also circumstances where governor has to refer it to the president for its consideration. D. Question number 7, answer D. Which of the following are functions to which the scope of discretionary power of the governor is limited? Here limited means he has discretion, certain discretion. Article 163 mentions discretion in certain circumstances. Discretion means without the aid and advice of the council of ministers headed by the chief minister. Hello? Hello? Good? Again. Copy. से कल जाइली पूरा परदिन जाइली किए सर्विसिंग करिया जने हाँ टिके मैं बुझी कहबी आपको क्लास रे अछि Which of the following are functions to which the scope of discretionary power of the governor is limited? Appointment of the chief minister is limited. In certain circumstances, the president governor may have the discretion, like when the no party secures majority, when there is a hung assembly, the governor may have the discretion to choose one of them, anyone as the chief minister. That is a discretion. But when in normal circumstances where a party gets majority in the Vidhan Sabha, he will appoint the chief minister, he will appoint the leader of the largest majority party in the Vidhan Sabha as chief minister. So there is no discretion. In certain circumstances, he has discretion. Dismissal of the ministry is not also a discretion every time. He will dismiss the ministry when only the House passes a resolution, a no confidence motion resolution against the government. So it is also limited. Dismissal, he cannot dismiss the ministry at any time. That is also. The resolution of the Legislative Assembly is also not a discretion. Assent to a bill is it is discretion. In which the scope of discretionary power of the President is limited. 1, 2, 3 I think. 1, 2, 3. In assent he may have discretion. Which of the following statement is correct? Is correct. In India, same person cannot be appointed as governor for 2 or more states at the same time. He can be, so it is incorrect. Judges of the High Courts are appointed by the governor of the state just as the judges of Supreme Court are appointed by the President. No, both judges of High Court and Supreme Court are appointed by the President. No provision has been laid down in the Constitution for removal of a governor from his or her post. That is correct because Article 156 mentions that governor holds office during the pleasure of the President. No procedure is mentioned for removal. That means he holds office during the pleasure under Article 156 clause 1. That means the President can remove the governor at any time. That is why answer C. In case of Union Territory, let us see what is the option D. But answer is C. In case of Union Territory having legislative setup, the chief minister is appointed by governor on the basis of majority support. That is also incorrect. It's correct, acha. It is incorrect, yes. So only C is correct because it is incorrect because the chief minister is appointed by the president. President of India. Question number 10. Consider the following statements regarding the executive power of the governor of a state. Executive power. Let us see the statement first. The Council of Ministers of a state holds office during the pleasure of the governor of the state. However, the members of the State Public Services Commission cannot be removed by the governor. Here the statement 1, I think individual responsibilities there. Ministers individually hold office during the pleasure of the governor, but during the but the Council of Ministers as a whole hold office during the pleasure of the House. The governor cannot remove them until the House passes a resolution against the Council of Ministers. So this statement, if you take individually, it is correct. It is not clear whether it is individual responsibility or collective responsibility. Anyway, that will be correct. You cannot say it is incorrect. Okay. However, members of the state public service cannot be removed by the governor. That is correct, because they are removed by the president. Removed by the president. In the same manner, the UPSC chairperson and members are removed. There are certain grounds. So I think it is the Council of Ministers. The Council of Ministers holds office during the yes, that is 164 clause 1. So both are correct. Both are correct. Both are correct. BC. Consider the following statements that is report which of the following, consider the following reports and state which of them are submitted before the state legislature by the governor. By the governor is not mentioned, but that is the point number 2, 3 and 4. Report of the State Public Service Commissioner submitted. Report of the Comptroller Auditor General of India, yes. Report of the District Planning Committee, no. Report of the State Finance Commission, yes. So 1, 2, 4. Answer A. Are submitted by Governor before the State Legislature. Consider the following statement regarding ordinance making power of the governor of a state. Ordinance making power of the governor of a state is a constitutional provision mentioned in Article 213. 1. He can use this power even at his or her discretion. No. Governor cannot use ordinances with discretion. Okay, so you can use not, I don't think so. This is what the case, the Supreme Court held that it is not a substitute for legislature, yes. It is a constitutional provision, yes. He can use this power only on the just 2 and 3. Okay. Question number 12, answer A. Question number 13. In which of the constitutional cases the Supreme Court held that whenever a doubt arises whether a ministry has lost the confidence of the House, the only way of testing is on the floor of the House. That is a very historic judgment in the SR Bomai case. Here ministry means the council of ministry at the state level. So the governor should not have the discretion. He should test it on the floor of the House. If the council of minister headed by the chief minister lacks the support of the or confidence of the majority of members of the state legislative assembly, then the governor can dismiss. Otherwise the governor should not dismiss the ministry as long as it enjoys majority in the state legislative assembly. That is a point to be noted. So here SR Bomai case versus Union of India 1994. SR Bomai, the ex-chief minister of Karnataka at that time. So that is C. In this case, the Supreme Court said that whether any doubt arises whether the ministry enjoys the confidence of the House or not, that will be tested on the floor. Here confidence means majority, support of the majority of members. 14. Consider the following statement. The term of the governor holds office during the pleasure of the president. It is mentioned in the Constitution under Article 156(1). Correct. The governor can continue beyond his term until his or successor enters. Yes. The above provision is, however, not mentioned in the Constitution. It is also mentioned in the Constitution that the governor will continue. It is mentioned in 156 clause 4. 156 clause 4. 156 clause 4. Clause 3, sorry. It is clause 3, article 156 clause 3 mentions that the governor shall notwithstanding the expiration of his term continue to hold office until his successor enters upon his office. And this provision is mentioned in the Constitution itself. It is 1. It is 3. So 2, 3, 1, 2, 3 are correct. Question number 14. 1, 2, 3, that is B. Consider the following statement. Advocate General has the right to speak and to take part in the proceedings but no right to vote in the House of the State Legislature of the state. Yes. Advocate General has a right to speak and take part in the proceedings but does not have right to vote. 1 is correct. The Advocate General is appointed by the Chief Minister? No. He is appointed by the Governor and holds office during the pleasure of the Governor. So it is incorrect. It is only 1. Which of the following is incorrect? Which of the following is not correct? 16. The governor can use his discretion in circumstances. Yes. Some of the circumstances where the governor can use his discretion are mentioned in the Constitution. Yes. Article 356, Article 200. Okay. The President of India has more constitutional discretion than that of the governor. No. The governor has more constitutional discretion than that of the president. President does not have more constitutional discretion, but the governor has a substantial discretion can be used as is mentioned in the Constitution. Article 200 deals with governor's discretion relating to state bill. Yes. So answer C, not correct. Which of the following is correct? The governor had the power to nominate 2 Anglo-Indian members to the State Legislative Assembly before 2020. Governor has the power to nominate 1 Anglo-Indian member. 1. Under Article 333 before 2020. The provision of nomination by governor has been abolished by 104 Constitutional Amendment Act CAA 2019. So that is wrong. 103 is related to EWS reservation. B. The President had also the power to nominate two Anglo-Indian members to the Lok Sabha. Yes, that is correct. Under Article 331, the President had the power to nominate two Anglo-Indian members to Lok Sabha, but now this provision has been cancelled or repealed. Powers of both President and Governors were not mentioned in the Constitution. It is mentioned in the Constitution under Article 333, under Article 331. So C is correct. Number 18. Which of the following about the governor of a state is not correct? Not correct. He is appointed by the President on the advice of the Cabinet. Let it be correct. On the advice of the Prime Minister. Obviously, because the decision is of the Prime Minister. He is usually an outsider. Yes. He can be reappointed for maximum 3 terms. No, for any term. So that is C. Let us see what are the D. He holds office during the pleasure of the President. Yes. 156 says that the Governor holds office during the pleasure of the President. C. The first Chief Minister of Odisha after general election, Navakrishna Chaudhary, general election 1952, but before that it was हाँ बड़ा मैं से फोन करती मोटामोटी ଏବେ କହିଦଉଛି ଆଉ ତମେ ଆସି ନେଇଯିବ ମୁଁ ତାଙ୍କୁ କହିଦଉଛି Okay, Dr. Harikrishna Mata was the first Chief Minister after independence, but after general election, Dr. Navakrishna Chaudhary was the Chief Minister. Number 19. 20. Which of the following is correct regarding governor of a state? No money bill can be introduced in the state legislature without his prior permission. That is correct. He has the power to issue ordinances if the legislature is not in session. Correct. The governor assumes power to rule the state during national emergency. That is wrong. So not correct. C. During national emergency, the Chief Minister does not resign. He stays there with the Council of Ministers, although the power of the state government and the state legislature are somewhat compromised during the national emergency, the power assumed by the parliament and the central executive more. So C is incorrect. There is no provision. National emergency, governor does not have any such power. 21. Who among the following became the Prime Minister of India without being earlier the Chief Minister of a state? Moraji Desai was the Chief Minister, Charan Singh Chief Minister, VP Singh Chief Minister, PV Narasimha Rao also the Chief Minister of Andhra Pradesh, VP Singh was Uttar Pradesh, Charan Singh was Uttar Pradesh, Moraji Desai was Bombay, Maharashtra now. So 1, 2, 3, 5 were the Chief Minister, and only 4 were not the Chief Minister. So answer will be 4 only, D. The Chief Minister of a state must be a member of which house? Chief Minister must be a member of either house. Maybe from Vidhan Sabha, maybe from Vidhan Parishad, but one thing that you must keep in mind that a person can be appointed as the Chief Minister of a state without being a member of the state legislature. He or she has to retain or secure a seat within 6 months from the date of appointment. Otherwise, he will cease to become the Chief Minister. So there is a provision that, but he should be a member of either house, either afterward or at the time of appointment. Doesn't matter. So D. Okay, now look at question number 23. He is the chairman of the State Planning Commission. Yes, Planning Board. He announces the policies of the state government. Yes, he is the chief spokesman of the government. D. The Council of Ministers is headed by the Chief Minister, is collectively responsible to Legislative Assembly. Article 164 clause 3 mentions that. Article 164 clause 3 mentions that. Clause 2 or 3. Clause 2. Clause 2. Article 164 clause 2 mentions that. Legislative Assembly. And collective responsibility to the State Assembly is the core principle of parliamentary democracy. Okay. So that is answer A. Consider the following statement. A money bill can be introduced only after the prior recommendation of the governor of the state. Yes, in fact, governor of the state can approve advance from the state contingency fund without the approval of the state legislature. That is also correct. Both 1 and 2. C. Which of the following statement is correct? The governor can refuse to give his assent to a bill. Yes, he can refuse, withhold his assent. The governor can reserve the bill for the consideration of the president. Yes, in certain circumstances. Governor can refuse to invite a leader of the party of Vidhan Sabha who does not command the majority in the house. Yes. The governor may dismiss the speaker of Vidhan Sabha and chairman of Vidhan. No. Because the speaker of the Vidhan Sabha and chairperson of Vidhan Parishad are removed only by the house after it passes a resolution in effective majority. So that is D is incorrect. All are correct. If the chief minister dies suddenly, what happens immediately thereafter? When chief minister dies, the council minister automatically resigns. Because he is central to the formation, survival of the council ministry. His first MO equal, he is the pivot around whom the ministers revolve. So when he resigns or dies suddenly, automatically the council minister will resign. This will be the first effect on the dissolution of the death of the chief minister. B. Governor of a state can reserve a bill passed by the state legislature for the consideration of the president under which of the following articles of the Constitution of India? Article 200. But president takes action under Article 201. That is 200. A minister in the state government is individually responsible to the governor of the state. Yes. Holds office 164(1). The governor can remove him on his own. No. Only on the advice of the Okay, so only one is correct, 29. Only one is correct. And the last question, which is the rank of the governor within the state of the W president, fourth rank. B. Within the state. Within the state, governor has fourth rank. But outside the state, it will be 8 outside the state. Okay, so we have discussed 30 very important questions related to governor. Hope that this will definitely help you out in working out your preparation for civil service examination. Stay tuned to our classes every morning. Every day we are launching various classes on various subject-wise discussion, free of classes, but questions are of quite important, quite educative. This will definitely help you in getting some relevant questions. We are designing the question ourselves and including some previous one in this session. Next session, I shall be bringing more questions on state executive with certain previous ones for your reference. Thank you very much for watching us. Stay tuned.